Welcome. We'll get started in just a moment. Okay, it's good to see some familiar names, familiar people joining us today. I know that a lot of people have been looking forward to this event. I know I have.
Thank you.
Just another 30 seconds and we'll get started. Okay, so welcome everybody. We will get underway now. So firstly, a bit of housekeeping. For those of you who haven't used Zoom webinar before, you'll see that there's a Q&A button at the bottom of your screen. If you do have any questions for our fantastic speakers as they're going along today, please put them in the Q&A section. But we will get started. Now, for those of you who don't know me, I'm Laura Skillen, the Executive Director of the International Mediation Institute, and we're also joined here by Jess Lowe, representing the Singapore International Mediation Institute. But I think it's just about time to get underway because I've been very excited about this event, and so we're going to start off with two fantastic speakers today, both representing Kenya and both talking about the Singapore Convention and mediation in Kenya. So firstly, I would like to introduce Ms. Beryl Ouma, who will be kicking things off for us. So welcome, Beryl.
Thank you very much, Laura. Greetings to everybody, wherever you are logged in from around the globe. Thank you for attending this webinar hosted by Dr. Kariuki, Muigua, and myself. We will be sharing with you a general perspective on the place of mediation. You should shortly expect us on board the United Nations Convention on International Settlement Agreements, from mediation, now popularly known as the Singapore Convention. May not be in the know is designed to enable cross-border enforcement in signatory countries of settlement agreements reached through the process of mediation of international commercial disputes. So those countries that have signed and ratified the convention agree in principle to ensure that international commercial settlement agreements shall be enforced by the courts in their respective countries upon hearing of applications made by parties to the dispute in those jurisdictions. So this, for me, I think I'd say I believe the greatest achievement of this convention, as I see it, is the fact that it establishes a harmonized legal framework for parties to invoke settlement agreements, as well as the enforcement of the same. But my learned colleague, Dr. Kariuki, will be speaking to you a little bit more about that. So I would just like to get back to my own country, Kenya, and give you, where we stand, where we are at. I'm pleased to let you know, starting with the Constitution of Kenya 2010, that's our amended constitution. So Article 48 of our Constitution, under the Bill of Rights, that's Chapter 4, expressly provides that access to justice is a right to all citizens. So to ensure that this access to justice is achieved under that same Constitution, Article 159, which generally confers and vests judicial authority upon our courts and tribunals, specifically at Article 159.2, provides that in exercising that judicial authority, the courts and the tribunals that I've just mentioned shall be guided by the following principles. So it talks about, it requires that justice shall be done to all, justice shall not be delayed, but most important and relevant to our discussion this afternoon or evening, wherever you are, is that it provides at part 3 that alternative forms of dispute resolution, including reconciliation, mediation, arbitration, and traditional dispute resolution mechanisms shall be promoted. I emphasize the word shall because it's couched in monetary. The other piece of legislation is the Civil Procedure Act, which is Chapter 21 of the laws of Kenya. This act generally provides for, procedure in civil courts in Kenya. So that act was amended at Section 59 to establish, this is pursuant to the Constitution of Kenya 2010. The Civil Procedure Act was amended at Section 59 to establish a mediation accreditation committee, which was to be appointed by the Chief Justice. So that act, or the amended section of that is Section 59A and 59B. In essence, once amended, introduced mediation to the management of court cases as a part of the civil procedure to be adopted by the courts in the country. I guess, in line, and to make sure that it was aligned to the aspirations of Kenyans as set out in the Constitution, which is the supreme law of the country. So that act, which is the Civil Procedure Act, also required that that mediation accreditation committee would, then determine the criteria for certification of mediators, maintain a record of them, and things generally managerial and administrative around mediators. So the legal framework that I've just set out led then to, or rather gave birth to the establishment of what we now call in the country court-annexed mediation. In April 2016, mainly in the commercial and family divisions of our courts. Happy to report really that statistics from those registries, the 2 registries that I've talked about, indicate that there has been tremendous progress. Previously locked in disputes, as in the resolution of those cases through mediation, has locked, monies that was tied, as a result of those disputes. So that represented a settlement rate of about 54% in the commercial division and 56% in the family division, respectively. So by 2018, mediation as a mode of settling disputes under the court-annexed mediation had been extended then to other divisions of the court as well, that is to the civil division, to the environmental and land courts, as well as the employment and labor relations courts. Shortly thereafter, as at October 2018, happy to report once again that court-annexed mediation had been rolled out to courts in other parts of the country, as in when we started, they just started with the high courts in Nairobi, that is in the capital, but by that was in 2016. By 2018, the program had been rolled out to other parts of the country. So in other words, we may have been late on the table, acknowledging mediation as a process for settling disputes, but as of today, I can say the country has embraced mediation in a big way, and we're making tangible progress. Now, court-annexed mediation has had and continues to have its fair share of challenges, in that as the need for mediators continue to increase, there are other issues that have come to the fore. Now, these issues, for example, are matters of quality control. How do you accredit, or rather the accreditation criteria for mediators, and generally the caliber of mediators that we are actually producing. At present, the Institute of Chartered Mediators and Conciliators, in short ICMC, where I am actually the vice chair, is the only body that I know of in the country that gives mediators in the East African region, in conjunction with Mediation Training Institute based in the US. Now, the other accrediting body remains the judiciary, but as I have, it's important to note that they primarily accredit mediators that will deal with matters in the next mediation. They mediators that will actually deal with matters that are given to mediators by the courts under the court annex mediation program. So they're the general mediators. They are accredited by the judiciary for a specific function. So it got me thinking that much as court annexed mediation in my country was designed to assist in settling of disputes faster, it remains a very formal process. And I have often wondered, it's got me thinking whether this form of mediation meets the attributes of mediation that have long been celebrated by those of us who embrace mediation as we have learned or have been taught about it, which is matters of speed, how you take care of settlement of disputes in the past, is issues of confidentiality, matters of volunteerism, matters of cost effectiveness, if I should say so. The manner in which mediation allows you the parties to be in an informal environment, flexibility that mediation also gives parties, and of course, the fact that mediation is expected and more often than not allows the restoration of relationships between parties that have had a dispute. Bearing that in mind, and I remind us of the point that I've just raised, that those mediators accredited by the judiciary, in my country, under the court annexed mediation, are accredited mainly, as I said, to take care of matters that are given to them by the judiciary. In my view, and if you ask me, it takes away the aspect of autonomy, from the parties, because a mediator is then generally imposed on parties. They don't have that flexibility to go and say that we want to, we've agreed on so and so to mediate for us this dispute. They have to take, because the court annexed mediation process is a process that is, as I said earlier on, is mandated under the law, under the civil procedure, cascading from the Constitution. So when a judge says that they're referring a matter to mediation, I don't think parties really have a choice in the matter. They are forced. It's almost like, we're doing away with you for now. Please try and mediate that matter. And then they appoint for you a mediator, and you're stuck with that mediator, so to speak. So in my view, I think it takes away the benefits, like autonomy. The other thing that I'm seeing with this process as it is in the country right now is that it also takes away the aspect of volunteerism. Like, if I have a dispute, if parties have a dispute, they volunteer themselves for the process of mediation. So I find that the situation as it is in the country right now doesn't, takes away that aspect from parties. Then you are forced to go if you volunteer, to be. Another aspect that I think away from parties is for privacy, because remember, court papers once filed generally become public documents. You cannot, as a mediator, if information leaks out, it won't be because the mediator leaked that information. It's once papers are filed in court, they're generally there. Anybody who probably accesses the registry can have access to that. So I find that because court annexed mediation is a process that is sanctioned under the Civil Procedure Act, parties find themselves attending a court-mandated process and not one that they have volunteered to participate in. So once again, I think it takes away that. Now, I didn't want to take too much time because we would like to allow you people to also ask us a few questions. But then against that background, the background of where we are with the court annex mediation, because that's what I can speak to loudly, to just give you the pulse or the tempo of mediation in my country, I'm convinced that we must send out a loud message to the world that it is safe for investors to consider our country for investment, if not for anything else, but for the simple reason that we provide a sound framework for mediating commercial disputes. And, more importantly, that we have ratified the Singapore Convention on Mediation so that the question of enforceability of settlement agreements within our jurisdiction does not arise. I think having looked at this and seeing the benefits of the convention, I would be scared. I would be a little bit slow-footed as an investor if I found that, if there was a dispute, I'm kind of just stuck with mediation in court. And that's not to say people are not mediating disputes outside, but the issues of enforceability, come into play. So I'm actually saying that at the end of the day, I think, and my senior will talk about this a little bit more, my colleague, Dr. Muigua, there is need for Kenya to move probably a little bit faster to get on board. As I mentioned earlier, we are yet to sign the convention, but ICMC, the Institute of Chartered Mediators and Conciliators, where I sit as the vice chair, is spearheading discussions with the Attorney General to establish how soon a delegation can be sent to New York, because I think that's the place of signing right now, to sign the convention. This then would make us the second country in the East African region after Uganda. Our neighbors, Uganda, already got on board and signed, but that I think would make us the second country in the East African region to sign the convention. I would like to stop there with those insights. I will allow Dr. Muigua to give you his take on the discussions of the day. Then probably we'll take questions later on. Many thanks to everyone. Dr. Muigua, I hand over to you.
Thank you very much. I have followed keenly your presentation, and I will not overlap, but I'll emphasize certain things like what are we discussing today? Mediation itself. There's an assumption that all of us know what mediation is. It took me a while to really know what mediation is at all. I never used to link it with negotiation until a professor told me, look, you have to begin with the negotiation. It begins with the negotiation. Two parties are talking. And if they reach a deadlock, they invite a third party who then helps them continue talking. So that mediation is a continuation of negotiation. And this is not to be confused, because if we do not get the concepts right, and that has happened even in our jurisdiction where mediation is confused with arbitration, we get everything wrong. At least in the Singapore Convention, which we are reflecting on today, it is defined. And one of the points that comes out of that definition is that the mediator does not have authority to impose
themselves
a result or a solution. So what the mediator then does is to help the parties to continue negotiating. And if they do agree, then they are able to put that agreement in writing. And it used to be the case that that agreement used to be treated as a contract. So the Singapore Convention comes in to solidify that, so that that written contract is now recognized across jurisdictions. The full name of that convention is the United Nations Convention on International Settlement Agreements resulting from mediation. But the crafters of it, realizing that that's a mouthful, they call it Singapore Convention. And Singapore Convention, I think, should not be read in isolation. It's part of the international legal framework. If you look at Article 33 of the UN Charter, it's very clear to the effect that if there is a dispute or a conflict within the world, it shall be sorted out or dealt with using mediation, conciliation, arbitration, international courts and tribunals, and diplomatic methods. So for a very long time, mediation has been with us within the international legal framework. I have worked with mediation since the year 2010, when I was attempting to do a PhD in the area. And my professors were asking me, look, we thought you are a lawyer. I mean, where does mediation come in? And I would then again go to Article 33 of the UN Charter. I'm glad to report that we've moved very far from there. And in the Kenyan jurisdiction now, we have Article 159 that repeats Article 33 of the UN Charter, but with a difference. It talks about traditional justice systems, yes, recognizing that in the Kenyan jurisdiction, mediation has been here for hundreds of years, really, informally, both commercial and involving family matters, land, environment. It's been here. But there's a recent recognition by Article 159 of the Constitution that came to save me, so that I'm still able to say I'm a lawyer. And you can look at the Constitution. And also the court annexed mediation, which has really taken root in Kenya. Article 159 talks about the judiciary promoting mediation, but I dare say that mediation would exist even without the judiciary, because judiciary is one of the institutions that is coming in to promote it. Right now in the Kenyan context, we are looking to come up with an alternative dispute resolution policy. I sit in that committee that is doing that, and I have told them the first thing you must read very carefully is the Singapore Convention itself. I have also told them that the next thing you must read very carefully is the UNCITRAL model law on international commercial mediation and international settlement agreements, because it does exist. Because the Singapore Convention and the model law can be used together. In fact, the Singapore Convention gives you an option to choose which one to go by.
Yeah.
The model law itself is a model that you can copy with adaptation to suit your local circumstances. We do know that conflicts are culture specific. So in one region, they could see something differently. So moving forward, I see a scenario where we adopt the Singapore Convention, but also we look at the model law itself and modify it for Kenya. And this is a process that is definitely happening. If we are looking at the ADR policy and involving all the stakeholders within the Kenyan context, then we are going to come up with a policy document that will inform the law on ADR, the law on mediation. I do know that there's a bill right now before Parliament on mediation. It's called the Mediation Bill. And earlier on, there was the ADR bill before Senate. Both of them are going through public participation. So I'll not say anything about them, but we've made our presentations. And we have told them clearly that in passing any bill in the Kenyan context, they must look at the Singapore Convention. They must look at the UNCITRAL model law on mediation. So the two are relevant in these contexts. For those of us who are joining the discussion for the first time, we reiterate that the Singapore Convention came about as a result of the challenges that were there. You have an agreement, but it's not recognized internationally as an agreement. It's just recognized as a contract. There was international arbitration, which was thriving very well after the New York Convention and the model law, but mediation then was suffering. Yet mediation has the capacity to do what is called resolution, to resolve. And that's very different from settlement. I was taught that resolution is a scenario where something goes away forever. So if you have a dispute and you resolve it, it doesn't come back. So mediation has a very strong capacity for the realization of access to justice. And you do know access to justice, and my colleague has spoken about it, as captured in Article 48 of our Constitution, is very important also internationally. If you look at the Sustainable Development Goal number 16, it's about access to justice. So any mechanism that can lead to access to justice, real access to justice, is worth looking at. So the whole world is alert about mediation. They are looking at it, and nobody tells you it's a weak mechanism. It's not, because where there has been an agreement, then it is a very powerful agreement. And what the Singapore Convention is looking at is that agreement then will cut across different jurisdictions. It can be enforced across different jurisdictions. What I look at it as building a bridge across very many different jurisdictions, so that commerce and industry can move on. Commercial relationships can be preserved. Remember, mediation is confidential. So the settlement that you actually put up is in your own terms. The proceedings themselves are confidential. And there was a realization that states could save on costs related to administration of justice. So the states cannot ignore the Singapore Convention. And again, regarding the Singapore Convention, it's very clear, the convention itself, it says that it applies to agreements resulting from mediation and concluded in writing by parties to resolve a commercial dispute. So it is restricted to commercial disputes, not family, not personal, just commercial disputes. That phrase in writing has really developed since 1958 New York Convention. In 1958, a pen was something like this. It was a pen, or maybe a feather from a bird. But in 2020, writing is very, very different, and it is electronic. So anything electronic, anything that can be electronically recorded, then becomes writing. So if you agree on something that is then recorded electronically, that can be recognized across the jurisdictions. There are certain requirements for the recognition of those settlements agreements. And it begins with the fact that there must have been an agreement by the parties, a discernible agreement by the parties. And there must be evidence that there was a mediation that was conducted somehow, resulting in that agreement. There's a need, of course, for mediators' signature. They'll be looking for it. Any enforcing authority will be looking for that signature. And it's important because it will show that there was indeed a mediation. So that document signed by the mediator is important. And you find this requirement in the Singapore Mediation Convention and also the in situ model law on mediation. So actually, if you look at both documents, you will see they are complementary. So if you're adopting the Singapore Convention, it will be very good if you look at the in situ model law, so that we are able to borrow the processes from there. How does a mediation, how is a mediation carried out? And you find those in the model law. And considering the success of the in situ model law on arbitration, this we anticipate will also be quite successful. There are also reasons for refusal to grant relief under the convention. For example, if one of the parties has an incapacity, if the settlement agreement is null and void under some law, and for those of us who practice law, you would see invalidity, null and void. Lawyers they use that quite often. They say null and void to mean it doesn't exist in law, or is inoperative if you have the mediation agreement that is inoperative or incapable of being performed for various reasons. Then there will be a refusal to grant relief. If the agreement is not binding, and I would imagine you would look at the national laws. Does it offend public policy? What does the law say? If it offends public policy, then it will not be binding. And public policy would be one of the grounds for refusal to enforce. And there are also other grounds set out in Article 5 of the Convention. They are also set out in Article 19 of the Model Law. They read almost the same word for word. And one of them is that if there's a serious breach by the mediator, and Beryl spoke about ethics relating to standards applicable to the mediator, there would be national standards, international standards, or the mediation. And also, it could be as a result of the failure by the mediator to disclose to the parties circumstances that would bring up justifiable doubts as to the mediator's impartiality or independence. Or a scenario where the mediator has conducted themselves in a way that materially exerts undue influence on one of the parties. So there is a power imbalance, and power imbalance leads to injustice in that regard. So if there is any of that, then it will not be enforced at all. The convention itself does say, and even analysts have said that it's consistent with the in situ model law. And the Singapore Convention or the model law can be used as standalone. So you can pick the Singapore Convention and then build your national law around it, or you as a standalone document, or you can pick both as complementary instruments as we develop national laws. In the Kenyan context, what we are then looking at is a legal framework that recognizes mainstreams mediation, but does not formalize it. So that it's there, like the main character, the character of mediation is not changed. So that if we say the mediation is confidential, then it remains confidential. Even in court annexed mediation, once the matter has been referred to you, so you've been forced to go into mediation, you still have your confidentiality. Indeed, there are provisions to the effect that whatever happens in mediation cannot be used as evidence in a court of law. So the Kenyan context is right there. And I did say earlier that mediation has been around for a long time. It didn't start the other day, but there's a contest between the very formal mediation and the informal mediation, with the informal being ignored in a very huge way. Within the policy, we are trying to map out who are the stakeholders in this whole process. And we are saying that it cannot just be the judiciary. Indeed, even if the judiciary didn't comment, mediation goes on. We've been able to identify over 77 institutions in Kenya alone that conduct mediation one way or the other. The problem has been they operate very independently. The silo mentality. One group does not know what the other one is doing. And the aim of that policy will be to harmonize the policy objectives. What is it we are trying to achieve with mediation, and then bring it within the formal framework without formalizing it. That is where we are in Kenya. And in Kenya, arbitration is really the more familiar mode of dispute settlement, which is unfortunate because negotiation happens every day, in everyday life, in commercial disputes, in personal disputes. So it's a more common one, but we've not been able to link negotiation with mediation. When we are thinking about mediation, even today, we start thinking about the court annexed mediation instead of the very informal mediation that goes on a daily basis. So I think there'll be a need to rethink the definition of mediation in English, in Kiswahili. Kiswahili is the language that we speak. What is it in Kiswahili? What is it in the local languages? What are we talking about? Because you could talk about mediation the whole day and people don't understand. And I've done that in conferences. I talk about mediation and then somebody says, yeah, that was a good talk in arbitration. So they still don't know what it is I was talking about. We need to have a harmonized framework, okay? And within the country, within Kenya, and across borders and regions. The Singapore Convention allows regional organizations to sign in, so that within the East African region, for example, there should be that conversation about how do we get on board in this in matters relating to this convention. We need a harmonized framework, what I called earlier, building bridges between very different legal jurisdictions. The commercial community wants answers. They want to resolve their conflicts very, very quickly, very fast. Can we give them that? And I think the answer is yes. Is Kenya going to sign in? From where I sit, yes, they are going to sign in. In the committee that I sit in, my own contribution was, look, let's finish up with the policy. We already have a zero draft. That will take a very short time. And then let's craft. Let's sign the convention. Of course, that's the job of the government. They'll do that. And then let's make law, a framework that reflects the best of the convention and the best of the in situ model law on mediation.
In situ model law.
Yeah, that's my personal recommendation, and I believe it will go on. So how do we get the best out of the Singapore Convention? I would say, look, let us adopt the convention. Let us set up a legal and institutional framework at the national level, at the regional level, that would support mediation. As regards the informal mediation, I would say let's mainstream it. Let's bring it on board. Let's recognize it, because it is very important for access to justice. And even without that informal, within that informal mechanism, there are many, many commercial disputes. You see, commercial does not mean international companies, really.
Yeah.
But it starts from those small enterprises that also cross borders. You see, cross-border trade between the countries.
Exactly.
And you would expect, for example, between Kenya-Tanzania border, Kenya-Uganda border, there are all manner of informal traders. If they are brought on board through a framework, then we are not talking about something futuristic. We are talking about something that can be done. There's also a need to involve other stakeholders, like the International Chamber of Commerce. They have a presence in Kenya, the Kenya Private Sector Alliance. As we develop a national framework, we then capture the big and the small. And there has to be public awareness as relating to mediation. What is mediation? Public participation, and the making of a national framework for mediation. So essentially, we are then saying Kenya is ripe as regards signing of this Convention on International Settlements Agreement resulting from mediation. It should do that, but the signing is just a starting point. The work will then begin, and we need to put up an institution, a legal and institutional framework that recognizes mediation, and then we move forward from that level. Let me leave it at that, then we can answer a few questions as we go along. I can see there are a few questions. Thank you.
Presentations. And just a reminder to anyone, if you do have any questions, pop them in the Q&A, because we've still got a bit of time to go through those. All right, so I'm going to read out this first question. So we've got a question here from Judge Alawak, who asks, court-annexed mediation in Kenya is mandatory mediation. Isn't that true? That's the way I understand it. Secondly, I have seen recent guidelines by MAC on court-annexed mediation virtual resolution. Can you say anything about those guidelines?
I get that. Laura, I didn't get you. Sorry.
Sorry, my internet's quite bad today. So Judge Alawak asks whether or not court-annexed mediation in Kenya is mandatory mediation. And then she has a second question. She said that she has seen guidelines from MAC, the court annexed mediation virtual resolution guidelines. are you aware of those, or perhaps can speak to them?
I can begin.
I'm not sure if you're keen or not.
It's okay. I think we got a gist. Yeah, Justice, yes.
Justice Aluoch is my friend, and she's in the room. And she's a mediator.
She's my friend too.
Thank you. She's asking, court annex mediation in Kenya is mandatory. Is that not true? Yes, it is, for matters that are referred. Only for matters that are referred to mediation. And initially it was family matters, then it was rolled on to commercial matters. So it's not mandatory for every matter. In some countries, it is mandatory to try mediation before you go on with a case. In Kenya, you can still file a case directly, but when a matter is now referred to mediation, it goes into mediation, but the court does not interfere. I've done a few court annex mediation. Once the matter is referred to you, the registrar does not seek to sit with you, does not ask you for proceedings, does not ask you for notes. But if you agree, then the settlement agreement is something that can be filed. And I've always argued that a settlement agreement can also be something like, we agreed, okay? Because the registrar should not know what you agree, really, except that we agreed, and the matter should be marked as settled, so that we then protect the confidentiality and we protect these ourselves from attack, in the sense that people will say the confidentiality has been taken away by the court, the voluntariness has been taken away by the court. Parties are still free to walk away from a mediation, even a court annexed one, and there'll be no penalties. Okay. There's the other part of that question about guidelines on, now the question has scroll it back again. It's something to be about online or virtual proceedings. With the advent of COVID-19, a lot of things have changed. The courts themselves realized they could not convene parties to come and hear matters before them. So there are all manner of protocols by certain organizations relating to online proceedings. And I would imagine the guidelines relate to online proceedings relating to mediation. And I've seen a few of them from different institutions that offer mediations. It's an attempt to actually make sure that a mediation is still confidential, is still run the same way, and the parties have party autonomy within it, but virtually. They don't meet and they use a platform. Thank you.
Yeah, I think that answers it.
Okay, we had another comment by Mangerere. James Mangerere is my teacher. He's the one who introduced me to mediation. So, but he's making a comment. He's saying we have private mediation and court annexed mediation. Are you there? Yeah.
Yes.
The country is trying to regulate mediation by coming up with a bill and a policy. They both require a lot of input from professionals in the field. I completely agree. We need a lot of input. I did tell you earlier on that we have over 70 institutions that one way or the other practice mediation. So how can you move forward without talking to them, asking them, how far do we go? In the committee that I sit in, the National Steering Committee on ADR, we have every intention of talking to them for the second time, because it's been done before, and ask them, what is it you would like to see? So if there's a bill right now in Parliament, my view is it's premature, because you cannot have a bill or an act before a policy, and if you do, you are bound to make very many mistakes. But I said earlier, I will not comment on what is before Parliament now, but my view is that we should hold on. Let's look at the policy, and that policy should be owned by the widest group possible, the widest, all those groups, all those 70-something groups should come in. The policy would seek to say, we have ADR, we have mediation. How do we recognize it without formalizing it? It should not be exclusive. It should not be seeking to throw out some practitioners. It should not be seeking to favor the formal ones and throw out the informal. It should be a level playing ground. So Margaret, I agree with you. There should be a lot of consultation. Nobody owns mediation. Even the judiciary itself does not own mediation at all. So nobody should regulate it in some manners that I've seen, and even criminalizing mediation. Yeah. Because if you now say you need a license to practice mediation, it means then when I'm talking to my daughter and my son, I need a license. And if I'm mediating between those family members over a commercial dispute, which is maybe chocolate, then I will need a license. And if I don't have that license, I'll be criminalized. Those are some of the problems that I see going ahead. Thank you. I see another question there. Can you throw more light on informal mediation framework and those that include traditional forms of mediation that has existed in our villages before now? The point is, in the African context, the negotiation was always the case. You see, conflict was viewed as something that is not normal, and it was avoided. In South Africa, they've been able to describe that as Ubuntu.
Ubuntu.
I am because we are. So you live in harmony, you live in peace and quiet. So that even if you have a problem with your neighbor, you actually send somebody to go and negotiate with the neighbor, to say something to that neighbor. And even when the neighbor walks over to your compound, you use that third person to say something to that neighbor. And at the end of the day, if the two neighbors cannot agree, there were many, many, many institutions that would then carry out either an arbitration or a mediation between the two parties, so that there's harmony within the villagers, the locals, the informal persons in that regard. So it is a mechanism that has lasted for very, very, very many years. But what we have done, and I think this is not correct, is when we were coming up with the court annexed mediation, we went to another jurisdiction and borrowed. I think we borrowed the Ontario rules without thinking about the local context. I did say earlier, we should be able to define mediation in Kiswahili. I haven't seen a Kiswahili version, and Kiswahili is a national language here. That means then you are missing out a huge percentage of mediators who would like to come on board. And then there is a mediation accreditation committee, which seems to recognize only professionals who can speak English only. Yet English is one of the many languages that are spoken within our jurisdiction and the region. So informal mediation is being ignored, and I think we cannot afford to continue ignoring the informal mediation networks. The traditional forms of mediation, I would call it negotiation and mediation, that have existed should be taken on board, because trade is not new, mediation is not new, that notion is not new. If you're able to sell it to that wider community, then we can do very well. Thank you. Beryl, say something.
Yeah, and I see here, I think, I don't know, probably it's tied to the one that you've just answered, Dr. Muigua. Are there any cultural news operators to know when working on cases in Kenya on the wider East African region? This is from Ilan Bass, I think. I definitely, I think then I just want to echo what Dr. Muigua has just said, that we have a bit of a disconnect at the moment in the way we sort of want to move mediation in the country, or the one that we're laying emphasis on, because there's lots of scenarios where we are finding that informal mediation is actually being ignored. And as you say, mediation existed way back when, from back in the years, when we have traditional forms that people mediated their disputes. So yes, to answer you, yes, if you came today, and I know I have gone and mediated a dispute in the northern part of our country, where you just have communities that are important. When you look at some of the things that they're fighting over, they come from what they consider, injustices over grazing land and things like that. And when you sit with them, they tell you how they sorted out these disputes way back then. And in fact, most of the time it's they have issues with the way the politicians are now forcing them to sort of settle the disputes. And when you sit with some of those elders, they tell you how they would like that dispute to be sorted out. And as a mediator, then you realize that, we need to go back, because it's not like we're bringing these people anything new. These forms of settlements of dispute existed from way back then. So I found myself that we've had to tap in to the elders, meaning and go by their traditions, and they tell you this is how we did it, this is how we did it. Our problem right now is that they that have come in right now, have poured money, and the essence how disputes were resolved by their elders is completely being lost. So to answer your question, I think if you come back to the ground and if we listened to the people, and that's why there is need to take views around the country on the bill that is currently, before Parliament, there is need for us to go back and listen, get public participation, and go back and listen to what people are saying, because indeed there is nothing new that we're really bringing to the table. We just need to find out what people have done in their different jurisdictions. And with Dr. Muigua, when he was saying, yes, we can sign the Singapore Convention, yes, we can take the model law, but we need to borrow that when we already have a policy and a framework, and find out how those fit into our own jurisdiction, and how best that can serve. One size does not fit all. I think that's what. Thank you.
You have, okay, fine. Just to add on to that is that conflict is culture specific. And I've learned that the hard way. So that in some cultures, you cannot even show emotions. Even if you have a conflict with somebody, you reason that karma will sort out that for him or for her. But in some other cultures, you can go and tell your neighbor, I'll sue you. And life goes on. So when you are mediating conflicts in a particular place, you would have to ask, how do people behave here? For example, even in the Kenyan context, if it's a Muslim region, it may help to cover your hair if you're a lady, because they will take offense from the word go if your hair is not covered. And you may want to know, how are people addressed here? And I think when we were beginning, we tackled that. How would you like to be addressed? So that in the UK and other European countries, in mediations, you would address somebody as Jack or John. In Africa and in Kenya, if you address an old man by his first name, you probably take offense. So you might want to know, how do we address you? Where do we sit? On the left or the right? If I'm a man, how do I address a woman? How do I greet them? If you're in Cuba, you might want to think about taking a cigar as a gift, because in some cultures, if you don't take food or water or that cigar, it's rudeness from the word go. So the mediation is doomed. So it is up to the international mediators to carefully look at what is it that is culture specific, and then apply it to the best, in the best way possible, so that you don't lose your mediation before you start. Thank you. The question about quarter-next mediation sets the matter aside for the parties to attempt to resolve the matter, and the parties may decide to walk out. How then does this remove the aspect of voluntarism? You see, the very fact that you're ordered into mediation
Absolutely.
Is offending enough to some people. But mediations do happen as a result of being ordered. For example, in Kenya in, I think, 2007, there were two groups that could not agree, and there was fighting on the ground. And the international community actually forced the two groups to the table. So the first act after the deadlock could be a third party forcing you to a table. It doesn't quite take away your autonomy, because once you're at that table, you can still continue to, you can still walk out one of the disadvantages of mediation is that it's non-binding. And one of the problems that the convention seeks to have is to make it binding across jurisdictions. It was not there before. Not as a contract, but as that process that culminated in this agreement, then recognizable across jurisdictions. I see another one. Are there any laws in Kenya under which the mediator or the parties may be required to disclose the proceedings of a mediation or the settlement agreement? So I can't think of any, but suppose the whole thing, the whole object of the mediation is criminal, completely criminal. Wouldn't you be forced to disclose at one point? But by and large, what happens in a mediation remains in a mediation. In fact, the mediator gets the parties to sign and agree that they will not, he will not be called as a witness. And I think one of the things we might have to look at is how to amend the law to ensure that the mediator is never called in court to give evidence. Laura?
Because then it doesn't protect them.
Yeah, Laura would like to answer this question live. Yes, Laura.
It's with you.
Yes?
Yeah, it's all good. But I think actually Vikram had a follow-up question though, because he's clarified that the reason he asked this question about disclosure is that he wants to know whether confidentiality is absolute in Kenya.
I have seen the court annex mediation rules. Court annex mediation rules, okay, and I have not seen. They do not say it's completely absolute. The word is not used there, but they try their best to protect the mediator, so that they say whatever is discussed within the mediation is confidential, and the mediator cannot be compelled to give evidence relating to that. That's very clear from those rules. Yeah. But from a public,
I think we would also, yeah.
From a public policy perspective, there are some things you can discuss there and then you're forced to disclose.
Perfect.
Yeah.
For example, if you're discussing something and then one of the parties gets killed, it becomes a criminal matter, isn't it? And what you discuss then, you would have to say what is it you are discussing, because you're in possession of crucial evidence. Remember, mediation law does not exist in a vacuum. It would then exist within the larger policy space and the laws of that country. James Mangerere says the issue of confidentiality has not been an issue here because we discussed the consequences of breach of confidentiality at the beginning of the session.
Yeah.
We usually tell them anything criminal is not confidential. So you can see Mangerere is already doing very well in that regard. You are covering yourself before you start. Anything criminal is not confidential. And I see that also in arbitration. Anything criminal is not confidential. It will be disclosed. Yeah, you can even be charged in the middle of proceedings. Yeah. Then I can see another question. As we look to grow in commercial mediation or other private mediation, do we have systems and experience with including mentees in mediation in Kenya? Yes, we have capacity.
The practice we have.
Huge capacity. That is what MTI has been doing since the year 2010. Developing mediators. We have capacity within Nairobi. We have capacity within the counties in Kenya. People who have been trained, the 40-hour mediation training sessions, and they're good. How many mediators do we have? We have thousands by now. So capacity we do have. And the capacity to run institutions, yes, we do have that as well. So we are growing commercial mediation or other private mediation. We are actually not growing it. We are having it recognized. It's already there. It's already there. So we're having it recognized and having some systems, national ones also, that recognize it. And capacity.
Yeah, and I was going to say, sorry to interrupt you, Dr. Muigua, is that a lot of institutions, and I know at least ICMC does that, we encourage any mediator who has a brief to have at least 2 mentees in session, or just to make sure. I think even at the judiciary, I mean, I see that the judiciary also have a program where they have mentees, but I know most mediators have taken to taking, just like you have the articleship or pupillage, carry some of these young ones along, or those who have just freshly qualified. And Mr. Mangari, I think, has also done very well. He's my teacher too. He has quite a bit of refresher courses for those who have qualified or those who just want to up their game, to elevate their game in mediation. So as you said, it's not something new, and I think we're just fighting for bigger space for recognition that this definitely is the way of the future for settlement of disputes.
Thanks.
I can't see any other questions.
I think we're out of time anyway, so I've tried to block the questions off. But thank you so much for this incredibly fascinating presentation. So thank you so much for, Beryl, Ouma, and for Dr. Kariuki Muigua. I promised I would say it correctly, for joining us today. This has been, I think, a really fantastic note and a fantastic addition to this series. So thank you so much for joining us. Thank you as well to the people who attended and asked such fantastic questions. And I mean, I think overall, I'm really glad to see that Kenya is really moving forward with mediation. It sounds like it's fantastically embedded and it's going to be a great future, I think.
Thank you.
Okay. Thank you everybody for having us and for giving us the opportunity to make our pitch or our presentations. Calling to Dr. Muigua for agreeing to do that.
Thank you everyone for listening to us, for engaging with us. We've reflected on quite a number of things, and we will continue the conversation. Thank you very much for the opportunity.
All right.
Thank you.
We'll see you all next time.
Thank you.
All right. Thank you. Stay safe.